Ladies and gentlemen, a very, very warm welcome. Thank you for taking the time to be with us today and welcome once again to our M&A Academy program. This is the 8th webinar in the 3rd edition of the program. My name is Samir Shah and I'm an M&A partner in Khaitan's corporate M&A group. Once again, I would like to extend a very warm welcome on this webinar to each and every one of you, whether you are in our audience in India or anywhere else across the world, as well as to those who will be viewing the recording on YouTube. For people who may be attending this program for the first time, this has been designed to impart foundational legal knowledge and understanding on M&A transactions and processes in a very corporate training-like environment for corporate executives, in-house legal teams, and anybody else interested in participating in the M&A ecosystem today. Our subject for today is how do M&A disputes arise? In almost every webinar in this series, disputes and how to address disputes tend to be a very prominent question from the audience. Yes, it does start with the contract and how you've structured the transaction, but typically, once a dispute has arisen, it is more often than not a question of competing commercial priorities of the parties. In today's webinar, we will use the case study method to elaborate on some common examples of disputes in M&A transactions, how they arise, and this will be done over different themes associated with M&A transactions. By all means, this is not exhaustive. There could be several other themes than the ones that we cover, but this should hopefully help bring some flavor on the broader type of transactional disputes. As always, we will have a formal presentation followed by a live Q&A session. So please feel free to submit your questions in the Q&A chat box and we will pick them up after the presentation is completed. If we are unable to address all the questions online, we will do so after the webinar over email. And as always, the presentation, the summary notes, and the recording will be shared with all of our participants, and the recordings will also be uploaded on YouTube. Allow me to introduce our speaker today. We have with us my partner, Sneha Janakiraman. She is a disputes lawyer based in our NCR offices, having more than a decade of experience. We circulated her profile over email to participants, but just to mention once again, she is an experienced and knowledgeable litigator and has advised several clients on such transactional disputes, including advising Docomo in their landmark dispute with the Tata Group. So without further ado, ladies and gentlemen, I now invite Sneha to deliver her presentation. Sneha, over to you, please.
Thank you, Samir. A very good afternoon to everybody. Thank you so much for taking the time to join us today. I will be covering a small subset of M&A disputes through the course of today's webinar, like Samir mentioned. By no measure is this going to be expansive or extensively covering all issues, but hopefully it gives you a good flavor of the most common disputes that occur. So I will start by covering some of the broad stages of these disputes and then go on to some of the key issues on which we see them before we go on to the key takeaways. As many of you may have noticed, India has seen an increased level of M&A activity post 2022, both in the mid-sized segments as well as the big behemoth deals. So what this has resulted in is, in fact, India being projected as one of the jurisdictions likely to be seeing some of the largest M&A disputes in the coming times. Before we get into what sort of disputes are common in these transactional structures, it's important to understand the three broad stages in which they typically arise. The first is the pre-signing stage. Typically, the pre-signing stage is at the stage of entry into term sheets, memoranda of understanding, exclusivity arrangements, confidentiality arrangements. This is really the kickoff to the transaction. And typically, disputes at this stage tend to involve issues around enforcement of confidentiality, exclusivity, and whether or not the term sheets are in fact binding in nature. But in our experience, typically disputes at this stage are less common because parties are more amenable to amicable resolutions since the transaction is still at a very early negotiation stage. The second subset relates to disputes between signing and closing. Now, typically, these are disputes where transaction documents have been signed, but there are CPs that need to be satisfied, or there are regulatory compliances that need to be effected that aren't in place. Again, in our experience, these disputes are less common relative to the third subset, really, on which our focus is going to be through the course of this webinar, which is post closing dispute. Now, these disputes are by far the largest subset of M&A disputes. They primarily relate to issues of breaches of representations, warranties, indemnities, exit options, valuations, etc. This really is the crux of the deal that parties have negotiated when gone south. So let us cover some of the key issues that relate to post-closing disputes, starting first with breach of representations and warranties. Now, as Samir mentioned, I will be going through this in the form of a case study. But before we get into the case study, let's first understand what a representation is and what a warranty is. A representation essentially is a representation of a fact by one party to the other. And a warranty is really a promise that the said fact will hold good on a forward looking basis. For example, if you look at the illustrations on the slide, representation basically says that the target's financial statements are accurate and prepared in accordance with GAAP. This is really a statement of fact that's valid as on the date of the statement. Typically, transaction documents have these statements be valid on the date of signing and closing. Similarly, if you look at the illustrative example of the warranty, it reads, the target company holds all necessary licenses and permits to operate its business, and these licenses will remain valid for the foreseeable future. So this is a forward-looking promise. And should there be a breach of either of these, typically transaction documents provide for the consequent risk allocation of the loss, which could be either in the form of an indemnity claim or if not, then in the form of damages. So parties, in case of a lack of indemnity, do have the option of either seeking specific performance of a contract or damages. Let's now explore how these disputes typically arise through two case studies. The first is the dispute between Avital and HSBC. Now, what were the facts here? Basically, HSBC made a $60 million investment in Avital on the basis of a representation made by Avital that it was on the verge of signing a contract with the BBC for conversion of its 2D library to 3D, which would generate a revenue of about 1 billion. Now, once this transaction closed in about 2012, HSBC got suspicious about whether or not this contract even existed. So it appointed two auditors, KPMG and EY, to carry out this audit. And what it shockingly found was that not only was there no contract in place with BBC, they were really nowhere near signing one. And in fact, most of the $60 million investment had been siphoned off by the promoters to their private accounts. Ultimately, this of course resulted in an arbitration where the issue to be decided by the tribunal really was whether Avital was guilty of fraudulent misrepresentation. The SIAC tribunal found that not only had Avital made a fraudulent misrepresentation to induce the transaction, it also held Avital guilty of the tort of deceit and awarded damages for the tort of deceit as well as awarded the indemnity claim. Before I come to the key takeaways from this transaction, let's also test this through another case study, which is the dispute between Daiichi and Ranbaxy. In 2008, Daiichi purchased the entire stake in Ranbaxy Laboratories, only to discover subsequently that the sellers had actually made false representations about the nature of pending US FDA investigations. As you know, Ranbaxy is a pharmaceutical company, and therefore regulatory compliance with the FDA's requirements is critical. In fact, it would have affected the ability of Ranbaxy to not only export drugs to the US, but also potentially other markets across the world. So during the course of the diligence, Daiichi had represented to, Ranbaxy had represented to Daiichi that this was merely a routine regulatory investigation and had not disclosed the nature and extent and severity of this investigation. So ultimately, of course, post-closing, this resulted in a dispute that was referred to an arbitration. The issue before the tribunal was whether the seller was liable for fraudulent misrepresentation. The tribunal, of course, found that the seller had fraudulently misrepresented the nature and extent of the regulatory investigation, which had a material impact on the transaction, to induce Daiichi to make its investment and awarded damages to the tune of 2,500 crores. Interestingly, in the Daiichi dispute, one of the defenses that Ranbaxy took was that during the course of the diligence, there were documents in the data room that reflected the FDA investigations were ongoing. There was publicly available information to show that these investigations were ongoing. In fact, Daiichi had initially sought indemnities in relation to this, which was subsequently dropped. So, really, Ranbaxy's argument was that the buyer undertook the risk of this investigation going south. The tribunal and the courts disagreed and held that there is no ring fencing of fraud, whether by express contract or through implied terms. Therefore, when parties are negotiating reps and warranties, it is critical to bear in mind the risk allocation that you're bargaining for. From a seller standpoint, it's important to ring fence your liability by making sure your disclosures are as accurate as possible. You don't want to be saddled with an arbitral award or a court decision that's going to land you pretty much in insolvency in some cases. From a buyer standpoint, you want to ensure value accretion for your buy. You want to make sure that you've had the fullest disclosures and complete visibility. In fact, one of the most critical rights in this respect could be informational rights that you bargain for in your transaction documents, which also we will explore a little bit down the line. The next issue that I would like to briefly cover is one on indemnities. Now, the second package of rights that are critical in such transactions really are indemnities. Now, it is to be borne in mind that all of the issues that we will be discussing today really are risk allocation mechanisms, just differing in the way they allocate the risk. Now, indemnities typically are risk allocation mechanisms that provide for losses to be compensated by the party in breach. There are two broad sorts of indemnities that you typically see in transaction documents. The first is general indemnities. General indemnities generally cover undisclosed risks and are caveated the moment there are risks disclosed. And the second category that could be crucial are specific indemnities. Now, specific indemnities typically cover disclosed risks. For example, if there is a huge litigation that's pending, for instance, in the Daiichi case, had it not been a fraudulent misrepresentation, but just a litigation monetary liability that could potentially have been 2,000 crores, then in the event of a disclosure of such risk, the buyer and the seller have the ability to negotiate an indemnity and account for that risk. So it can be a useful tool from the standpoint of both parties. Let's test how this played out in the dispute between Jet and Sahara. Jet Airways acquired 100% of the share capital in Sahara from the sellers. The transaction document provided, the SPA, provided for an indemnity which stipulated that for any tax liabilities that would accrue for the period prior to closing, it would be the seller who would be liable for it. It also provided for a threshold of 50 crores when this would be triggered. Needless to say, after the closing of the transaction, the IT department issued a demand on Jet as a successor in liability to Sahara for an amount of roughly about 107 crores, which is payable in three installments of 37, 35, and 35 crores respectively. Jet made the initial payout of 37 crores and called on the indemnity against Sahara. Sahara refused to honor the indemnity and it ultimately went to the courts for litigation. The issue really was whether Sahara was liable to pay indemnity to Jet Airways under the SPA. Critically, the courts found that a crucial difference in an indemnity provision is that the holder is liable to claim specific performance of the contract of indemnity as long as it is shown that the liability is absolute. The holder of the indemnity does not need to go out of pocket. And this can be a very powerful tool in a transaction structure where you're looking at a large liability where a party may not necessarily want to go out of pocket in order to be able to make the seller or the counterparty pay for a liability or risk that has already been accounted for. So this is something to be borne in mind by parties and risk allocation. So this is something we often see from an enforcement standpoint in terms of the difference between a damages claim and an indemnity claim. It should be borne in mind for damages under the Indian Contract Act and the statutory regime that applies. For a party to be able to claim damages, the party needs to show that a loss is directly flowing from a breach, the loss is foreseeable, and the loss has been incurred. When you contrast that with an indemnity provision, really, all that the party has to show is that it is the beneficiary of a contract of indemnity. The indemnity covers the event concerned, and that the liability is absolute. There is no need for the party to go out of pocket. So this again can be a very powerful risk allocation mechanism that parties may want to consider from an enforcement standpoint. Moving on, one of the key rights that investors typically like to look at are the exit rights. Now, what are exit rights? Primarily, exit rights are aimed at ensuring that the investor is able to exit the investment at an advantageous position or at least ring fence his or her liability. Typically, they take the form of a mandatory IPO in a time bound manner or drag along rights, tag along rights, put options, call options, and are essentially ensured to ensure value accretion for the investor. Now, one of the critical decisions that explored how the courts in India and tribunals are looking at enforcement of these contractual rights was the decision in Entity Docomo versus Tata Sons. What had happened in this case was that Docomo had acquired 26% of shareholding in Tata Teleservices Limited, and there was a shareholders agreement that was entered into between Docomo, Tata Sons, and Tata Teleservices Limited. Now, the shareholders agreement provided that in the event certain key performance indicators were not met by Tata Teleservices, Docomo would have the right to invoke an exit option, as a result of which Tata Sons really would have to ensure that the shareholding of Docomo is bought out at the agreed value. So essentially, the shareholders agreement provided for a floor price to ensure that the risk to Docomo was not over 50% of its investment. Unfortunately, Tata Teleservices did not meet the second KPIs, and in 2014, Docomo did exercise its put option to exit the investment. However, Tata failed to honor its obligation, as a result of which this was referred to an LCIA tribunal for arbitration. What did the tribunal find? The tribunal really found that the contractual bargain that was struck was valid and enforceable. The defense that Tata sought to take to this was that the minimum price that was guaranteed under the SHA was really against international pricing regulations and would also be in violation of Indian foreign exchange norms because it required special permissions from the RBI for the remittance that would follow any such award. However, what the tribunal found was that the obligation to ensure the exit at the agreed value was an absolute contractual obligation that is enforceable. The tribunal found that this could have been effected through either general permissions of the RBI or by finding another non resident buyer where the RBI regulations would not play a role at all. Secondly, the tribunal held that its award really was the nature of enforcement of the contractual damage and the ensuing damages that were awarded. Therefore, it had nothing to do with remittance under the Indian foreign exchange regulations. Of course, Tata challenged this before the Delhi High Court and unsuccessfully, where the court agreed with the findings of the tribunal. So, what really is the critical takeaway from this decision that we have? The critical takeaway is that both tribunals and the Indian enforcement courts are looking at contractual bargains very stringently. So, unless there is an illegality in your transaction that goes to the root of the Indian public policy, courts are going to honor your contractual bargain. So there is no getting out of the bargain because regulatory compliance is willing to be effective. Therefore, how an investor structures their exit from a transaction can again be a very powerful tool to ensure value accretion. Moving on, the next issue that I would like to cover briefly is non-compete disputes. Now, non-compete clauses are very common in M&A structures. Typically, they're ensured at protecting the investment for the buyer so that the key managerial personnel or directors of the seller are not involved in a competing business. Under Indian law, Section 27 of the Indian Contract Act circumscribes in what circumstances non-compete provisions could be enforceable because it has a prescription against a restraint of trade or profession. So the limited exception to that is when the business is sold along with goodwill. And even in such situations, court typically look at both the geographical and temporal limitations of the clause to see if it's reasonable. Public policy in India mandates that there can be no restraint of trade or profession, barring in the limited exception. So it's really in that limited exceptional space that you're looking at enforcing these clauses, and therefore, how you draft them for enforcement can be very crucial. Let's test this through the decision in Arvinder Singh versus Lal Path Labs. What actually happened here? Lal Path Labs entered into an SPA for acquiring 100% of the shareholding in Amulak Diagnostics from the sellers, who were Dr. Arvinder Singh and Dr. Rajvendra Kachwaha. The SPA had a non-compete clause which restricted the sellers at any point of time from directly or indirectly carrying on a business that competes with that of the business acquired. However, subsequent to the closure of the transaction, both of the sellers took up a competing professional responsibility with a competitor, which was competing with Lal Path Labs. One was in the capacity of a pathologist, the other in the capacity of a radiologist. Now, Lal Path Labs sought to enforce this non-compete provision and approached the Delhi High Court in this respect. The issue really was whether non-compete clauses of this nature were valid and could extend to restraining a party from rendering professional services. What did the court find? Again, the analysis draws back to Section 27 of the Indian Contract Act, which is really the crux of this regulatory regime. The provision makes a distinction between a profession, a trade, and a business. A profession really is an expertise in a skill set as opposed to a business, which is literally aimed at a profit and loss venture with its own setup. So the court made this distinction between the two and held that while goodwill is sold, a competing business cannot be set up, whether covertly or overtly. Set 27 does not permit a party to restrain a counterparty from discharging any professional responsibility because that would amount to an absolute bar on carrying out any profession, and that exception does not exist under the Indian Contract Act. Therefore, what parties need to bear in mind in drafting such clauses from an enforceability standpoint is to be aware and mindful of the fact that while you can protect your acquisition from a competing business, what you cannot protect your acquisition from is a KMP or a director discharging mere professional responsibilities with a competitor because that is not likely to be viewed kindly by the Indian courts. The next issue that I would like to touch upon, and probably the crux of most of these investments, is valuation disputes. Valuation really goes to the heart of how the buyer is valuing the company at the time of entry. Typically, valuation issues arise when either there is undervaluation of shares, inadequate disclosures, misrepresentations, etc. So, one good example of testing how valuation disputes pay out even post acquisition is the dispute between PNB and SEBI. Now, PNB Housing Finance is a listed entity. Punjab National Bank was unable to secure further funding or financing for this entity, as a result of which PNB Housing Finance decided to raise capital through preferential allotment to four specific companies. Now, what should be borne in mind here is that the Articles of Association of PNB Housing Finance provided that in instances of preferential allotment, there would need to be a valuation exercise carried by registered valuers before the shares could be allotted. However, what is critical again to bear in mind is under the SEBI ICDR regulations, all that is required is for a floor price test to be met. And in this case, the shares were actually being allotted by by PNB Housing Finance, well above the floor price. However, because a proxy firm raised an issue with the price at which the shares are being preferentially allotted, ultimately, SEBI issued a notice restraining PNB Housing Finance from convening the EGM for approving the issuance of this preferential allotment. The issue that went to SEBI and ultimately SAT was whether the articles of association of the company would prevail in terms of determining value when statutory requirements have already been met. Unfortunately, SAT delivered a very indecisive verdict on whether or not the terms of the articles would prevail. But subsequently, as a result of this dispute, SEBI amended the ICDR regulations requiring that if the AOA provides for a method of determination which results in a floor price that is higher than that is provided by the regulations, then the AOA will prevail. So it needs to be borne in mind that when typically post-acquisition articles are amended and such stipulations form part of it, any subsequent capital raised by the company could be impacted by the terms of such articles. The next dispute that I would like to cover, and in my view, the most interesting one, is one on material adverse effect clauses. Now, MAC clauses, for better or for worse, have not been tested extensively in India. However, they have been the topic of a lot of interest ever since the post-COVID period in 2020. So let's test MAC clauses for what they really do. MAC clauses are really a risk allocation mechanism to ensure that both the buyer and the seller get what they bargain for. Primarily from a buyer standpoint, they are designed to ensure that if there is a significant material impact on the finances or operations of a target, then the buyer has the opportunity either to renegotiate or walk away from a deal. As I mentioned, these clauses have not been extensively tested in India. So let's try and test this from the standpoint of a leading decision on this issue, which is Acorn versus Fresnius, which was decided by the Chancery Court in Delaware. What were the facts of this case? So Acorn and Fresnius basically executed a merger agreement, post which Acorn's business performance really fell off a cliff. This was largely because of competition in the market, which adversely affected Acorn more than it did its competitors. It lost a very key contract as a result of which also its business performance was very adversely affected. Now, Fresnius also discovered after the signing of the merger agreement that there was large-scale FDA compliance issues with Acorn. It's important to bear in mind here that the merger agreement provided Fresnius with extensive information and access rights. As I mentioned previously, this can be a very critical tool, especially between signing and closing, when parties have had inadequate disclosures or incomplete disclosures or even non-disclosures that can affect a business materially. As a result of this information and access right, Fresnius was able to discover the extensive FDA violation and compliance issues, and this also discovered the remediation effected by Acorn was really not effective. As a result of this, Fresnius terminated the merger agreement. The issue was whether Fresnius was entitled to terminate the merger agreement with Acorn by invoking the MAE clause. Now, both the Delaware Chancery Court and the Supreme Court agreed with Fresnius. It should be borne in mind that even under Delaware law, the burden of proof lies with the party invoking the clause and is relatively high. Despite that, they found in favor of Fresnius on two issues. One is they found that there was a breach of the representation and warranty concerning regulatory compliance. In this case, Acorn had failed to comply with its regulatory obligations in terms of the FDA compliance required. And this actually had a significant impact durationally. So they found that it would take about 3 to 4 years really for this to be remediated. And also in terms of cost, they found that it would be 20% of Acorn's standalone value. Therefore, they found that the breach of this representation warranty had a significant material impact on the transaction. Second, the EBITDA of the company had fallen off the cliff. A company that was profitable year on year was making significant losses, as a result of which they found that Fresnius would be able to walk away from the merger agreement. It should be borne in mind that in this case, the transaction document provided for such robust MAE clauses to ensure that breaches of reps and warranties that resulted in material effects, whether operationally or financially to the company, would actually allow the buyer to walk away. As I mentioned previously, unfortunately, these clauses are not extensively tested in India. Typically, what we do see in Indian jurisdictions is parties trying to walk away from these clauses on the basis of two provisions. One, force majeure, which is typically a contractually agreed provision on when parties will walk away, including natural disasters, calamities, strikes, etc. Second is discharge of the contract due to frustration. So when a contract does not contain a force majeure provision, but the entire purpose or the foundation of your contract is frustrated, then parties typically invoke provisions of the Indian Contract Act for a discharge of the contract. This is largely the gamut of post-closing disputes that we see in context of M&A transactions. Now, unfortunately, due to constraints of time, we won't be able to go into the pre-closing disputes or disputes between signing and closing. But what this does give us a flavor of really is three very critical things for parties to bear in mind in such transactions. First is it is absolutely indispensable to go through a thorough and comprehensive due diligence. That is not to say that a thorough and comprehensive due diligence will ensure or mitigate all risks. There's always the possibility of non-disclosure, of fraudulent misrepresentations. So what really the diligence translates to is a well-defined and well-negotiated package of rights and obligations in the form of relevant representations, warranties, undertakings, indemnities, sometimes price adjustments when you know that there is a liability that the target has to absorb post-closing. And the last and the most important piece is, of course, effective enforcement mechanisms. There used to be a time when dispute resolution mechanisms were really midnight clauses that were put into contracts. That's no longer the time, which can only be a positive impact on these transactions. Essentially, it is critical for parties to understand the nature and manner in which the disputes mechanism needs to be structured, whether it needs to be multi-tiered, whether it needs to be singular. If it needs to be multi-tiered, for example, if your dispute resolution mechanism needs to have an amicable negotiation or settlement or a mediation period that needs to be preceded before you move on to either arbitration or a court litigation, then it is important for you to define who the players are going to be on either side leading these mediations or negotiations and what timelines you're working with. Is it going to be 30 days, 60 days? This will lend a level of certainty to your dispute and end also satellite litigation in terms of when adversarial processes can be triggered. Moving on to the adversarial process, given a jurisdiction like India can be quite saddled in terms of time, court processes is not what we typically see in such transaction documents. It is typically arbitrations. So even in arbitrations, it's important to understand what is the deal size. Is the seat of arbitration going to be in India? Is it going to be outside of India? And this can make a lot of difference in terms of the strategy that you adopt for the disputes. For example, if you were to choose a foreign seated arbitration and invoke an emergency arbitrator's award, it's important to know that that's not enforceable in India. So your dispute strategy will be driven a lot by the parties to a transaction, the transaction size and risk matrix, and how you choose to enforce those rights and obligations. Also, obtaining immediate interim relief is something that's typically critical in such transactions and can also drive a lot of the negotiations and settlements. So, in sum and substance, it's important to be thorough at all three stages, starting with comprehensive due diligence, a well negotiated transaction package, and definitely an effective enforcement mechanism to ensure that you receive the value you bargained for. Thank you so much for your time and attention. I'm happy to take any questions.
Thank you very much, Neha. Why don't you maybe take a moment? Uh, I can tell you we have enough and more questions. We, in fact, had a lot of questions come in as a part of the registration as well. And now I can see we have a few and more in this entire chat box. So why don't we do this? You mentioned Docomo, I mentioned Docomo when I introduced you. So why don't we maybe start with that? And there are
Sure.
three or four different questions around the entire Docomo case. And again, it's in public domain, so we can talk about it a little. But essentially, it is the interplay between foreign exchange laws and contractual rights. And really, how did we navigate that? Maybe you want to spend maybe a couple of minutes on that if you want to talk more about Docomo.
Sure, Samir. Happy to. So I think Docomo was sort of seminal in that, earlier the regime that existed was public policy was your get out of jail free card. So the moment anybody invoked a statutory violation or even a potential statutory violation, courts would, fold and say, okay, I'm sorry, it's against Indian public policy, it's not enforceable. So in that sense, I think Docomo broke new ground with the court clearly signaling that it is going to hold parties to a bargain. And it's also important to bear in mind that's distinction I was trying to make out also through the presentation that there is a difference between a regulatory compliance that is required in meeting your contractual obligations and an invalid clause. Now, this was not a situation where Tata could not have performed its obligations or would have been in breach of Indian foreign exchange laws had it performed. It had the option of finding a non resident buyer, in which case the obligations wouldn't be triggered at all. Alternatively, it had the option of obtaining the requisite compliance. In fact, the court found that it wasn't even clear that the general compliance that already existed wasn't sufficient. So, really, this was clearly an instance that was not triggering a public policy violation. The court chose to make that distinction and chose to sort of set the path to say that contractual obligations are sacrosanct and parties can no longer walk away by just pulling up a statutory obligation.
Understood. There's a lot of other questions around downside protection and how Docomo sort of veered into it. So I think that the overall message you've given is perfect. There are ways to structure around this to get parties comfort. And it's really important to, like we've been consistently saying, work with counsel who understand this. Now, I have a slightly more broader question, Sneha, which I've been meaning to ask. So you mentioned in some cases, we've obviously taken 6 or 7 different themes, but there can of course be a lot more. If you have to summarize on a more overall basis, what in your experience are the more common causes that lead to disputes in M&A transactions?
So, in my experience, the most common causes of disputes in M&A transactions are commonly centered around reps and warranties and indemnities, honestly, because I think sometimes the diligence can be either rushed or it could be inadequate at the time of the diligence when parties are in a hurry to close the transaction, or half disclosures are made or no disclosures are made, and that typically does result in breaches and disputes. So that, in my experience, is the most common cause. And the second, of course, from coming from an enforcement lawyer standpoint, but I'm happy to say this has changed a lot in the last few years, is effective enforcement mechanisms. So sometimes you have an excellently negotiated transaction package, you have a great set of rights that you enforce, but you have no effective way to enforce it. So that has changed also. So I think parties are thinking through the transaction structures, not just from the rights package standpoint, but also really ultimately the enforceability standpoint, so that at the end of the day, where you are not in agreement, you have a way to get out where you want to be.
Understood. Hold that thought on disclosures because there are a couple of questions I need to read. In the meantime, can you maybe let's start before diligence is your term sheet and MOU. And there were a couple of questions, and even in our earlier sessions on term sheets. Are they truly binding? Are they non-binding? If there are disputes, what are the kind of disputes you see?
Sure. So yeah, like I said, so we see less at the sort of the pre-closing stages, largely because parties are still, at the stage of negotiation. They tend to find a negotiated settlement even as a dispute. But obviously, we see disputes around enforceability of MOUs and term sheets. Typically, where transactions don't close and parties really want to reinforce their positions. Now, these mostly relate to whether the term sheet in and of itself is enforceable. Is it an agreement to agree? Is it actually an enforceable agreement? Or alternatively, around confidentiality, whether a party has breached confidentiality in walking away from the transaction. The third is around exclusivity. Has a party really breached their exclusivity during the period when it was supposed to be held sacrosanct? So these are typically the sort of disputes that we see at the MOU and term sheet phase. And this becomes even more interesting where, the transaction is not 100% closed. If the seller still has a stake in the company concerned, that also drives negotiated settlements more, because nobody wants to get into a full-fledged arbitration at that stage. So it could be an advantage as well, but this is broadly the sort of disputes we see at that stage.
Understood. There's in fact a connected question. So, if a party breaches exclusivity, what are the chances of receiving an injunction restraining that party from breaching exclusivity?
So if a party, again, injunctions are typically fact-specific questions, but let's assume, I'm going to hypothesize that there's a 60-day exclusivity period, and on day 30 you have discovered that a party has breached its exclusivity obligations under the term sheet. So I would say that your chances, depending on the commercial code you're before, are pretty good, as long as you can show that the term sheet or MOU is actually an agreement and not an agreement to agree. Then you're in good terms to go to a court and say, I have 30 more days of exclusivity and this cannot be breached, and your chances will be fairly good.
Interesting, interesting. So now let's move from the term sheet. Let's follow the life cycle of the deal. So we are in diligence. Again, due diligence findings, how they've been communicated by buyer's advisors to the buyer, to the extent of diligence, what has been found in diligence, and how to what preventive measures to take. Do you see disputes arising from that, and whether the diligence itself was done properly or not?
Oh, absolutely. So diligence, in my view, is like the biggest driver, because it really defines your entire transaction package and what you get out of it in terms of refs, warranties, indemnities, covenants, price adjustments. So again, like something that we get very often also is disclosures that relate to these reps and warranties and whether they caveat liability, all of which is driven by diligence. So the moment there is a disclosure, the moment whether the diligence is not. In fact, that's exactly what I was trying to flag even from the dispute in Daiichi, where the significant FDA compliance violations they tried to get out of by claiming that the documentation related to that was actually available in the data room. So separate question that there was an issue of fraud involved as a result of which Ranbaxy didn't succeed with that argument. But I don't necessarily see that as a bad argument where a party actually has, and it's not a case of fraudulent misrepresentation, where it's simply a case of non-disclosure, insufficient disclosure. If there is some disclosure made on the data room that a reasonable person may deem sufficient to discover the issue at hand, it is a good defense. So diligence is very, very critical in the kind of package, in the kind of rights package that you negotiate.
Understood. So maybe on disclosures itself. So it's very common to have disclosures from sellers that qualify warranties. How often do you see those disclosures or the completeness of those disclosures getting called into question in disputes?
We do. So I will say that we don't see a huge amount. We see a lot more on reps and warranties. We see a lot more on indemnity claims, but we do see issues on sufficiency of disclosure. Typically, more actually at the negotiation stage and whether or not you accept the given disclosure than at the enforcement stage, because disclosures can qualify the warranty concern. What it really means is that even if you have a warranty in place, the breach of which would normally entitle you to damages, the moment the counterparty has disclosed that to you to caveat that right, you're on a back foot. So you better have had clear diligence to ensure that the disclosure is either sufficient or have it rejected. And in fact, with the onset of warranty and indemnity insurers now, it's become even more critical to ensure you're accepting the right kind of disclosure at the transaction stage and ensuring that any disclosure that's given to you is sufficient and clear. Otherwise, it becomes a huge risk from a buyer standpoint.
Understood. Understood. In terms of misrepresentation, do you perceive as a disputes lawyer any differences between innocent misrepresentation versus say, a deliberate or fraudulent misrepresentation?
Yes. So innocent misrepresentation typically will entitle a party to rescind the contract. It may not necessarily result in damages unless you can show that you have suffered a specific loss as a direct consequence. Whereas when it comes to fraudulent misrepresentation, damages will follow apart from rescission of contract. Of course, the quantum is again debatable and fact specific, but typically they do follow. And additionally, you also have other remedies, like you can sue the counterparty for the tort of deceit. You can maybe, depending on the facts, also look at penal consequences against the counterparty. So it has a level of pressure that's beyond just a monetary claim that makes all the difference between the two.
Understood. And in terms of the quantum of a monetary claim, and there are in the past we've seen clients ask, how do you quantify damages? What is the measure of damages in a transaction of this nature or in a breach of this nature? How do you what has been your experience on that?
So typically under Indian law, damages tend to fall under two broad buckets. So one bucket is liquidated damages and the second is unliquidated. So let me first address liquidated. Liquidated damages are instances where the contract provides a cap in terms of what the loss would be. Now, what should be borne in mind is typically parties assume that, let's say, a clause provides that in case of a breach or rep of warranty, your maximum liquidated damages is 10 crores, then your automatic entitlement is not to 10 crores. The party that is claiming the liquidated damages still has to prove that the actual loss that it suffered is equivalent to 10 crores, where it is possible to do so. It's only in rare instances where there is no mechanic for a party to prove what the loss would be, that the amount would be taken as a natural damage. The second subset, of course, is unliquidated damages. So, where your contract doesn't have a number pegged for what your loss is going to be, courts will typically undertake the exercise of determining whether the loss is caused directly by the breach, whether the loss is remote or not, and also exactly to what extent have you suffered the loss. You will again have to lead their evidence and prove it. So these are broadly the two kinds of damage that you see. Frankly, between the two, there's very little difference in terms of proof where proof is possible. In as much as in liquidated damages, there is a ceiling. So that's really how the two mechanics will operate.
Understood. Understood. Then maybe if we just switch for a moment and just in terms of earnouts, contingent payments, deferred consideration, to what extent do you see them playing a role in post-closing disputes?
I think significantly, depending on the volume, depending on the value that's riding on it. So typically, earnouts and contingent payments again are risk allocation mechanisms that the buyer or the seller has negotiated, knowing full well that they're expecting a liability to fructify or potentially may fructify. So this involves really efficient management, clear reporting, and disputes around this tend to crop up again, especially in instances where sellers are still holding some level of the stake and the company hasn't performed or a contingent liability has crystallized. if the transaction documents don't clearly provide the metrics that need to apply to such payouts, then it is a recipe for disaster.
Understood. So if we now look at post-closing conduct, and you mentioned a few things on non-compete clauses, we have some different questions. So, for example, are there restrictions under Indian law on non-compete? How do you circumvent those in a transaction? There are related questions, say, on non-solicit clauses. Overall, this sort of post-closing conduct, how do you navigate those, and what are the kind of disputes we see? We obviously saw some examples in the presentation.
Sure. So yes, so non-compete and non-solicit are really two sides of the same coin, I suppose, in one respect. So non-compete provisions, like I mentioned, are regulated by the Indian statutory regime, which is the Contract Act. So the public policy is to allow parties to carry on trade and business and not to restrain them, except in limited circumstances, which is when the business is sold with goodwill. So typically in M&A situations, BTA situations, where you're selling your business with the goodwill, these clauses are enforceable, but again, there is a limitation of reasonability. So you will have to show the court that there is either a geographical or a temporal limitation. For example, it can't be that the KMP or the director is restrained for time immemorial for a large geographical region, let's say the Asian subcontinent, from carrying on a competing business. It has to be reasonable. So that is a limitation that courts tend to impose. And of course, there's a difference between business and profession, like we just saw. So professional engagements will not be restrained. Only business engagements, competing businesses will be restrained. As far as non-solicit obligations are concerned, they are generally enforced, especially in respect of KMPs. So we typically see them being enforced in instances where either deals don't fructify fully and a party alleges a counterparty is trying to solicit key employees, or in instances of employment and labor disputes. So this is where we typically see these kind of clauses being enforced.
Understood. There's a question on cross-border arbitration and cross-border transactions as to how you ensure you retain the ability to procure quick and efficient interim relief.
Okay. So we get this quite a lot. So typically in cross-border transactions, like I mentioned, it's important for you to understand the metrics of your own transaction. So if your counterparty is Indian and you're going to ultimately seek enforcement in India, I'm happy to say that the regulatory regime has come a very long way. In fact, very recently, the Indian Supreme Court has held that in India-seated arbitrations, even emergency awards by various institutions will be enforceable like an interim order of an Indian court. The statutory regime has been revised to ensure that arbitral awards are now time bound. Typically, arbitrations in India take under 2 years on average. Interim reliefs are very readily available in commercial jurisdictions if you can make out the metrics of. In fact, courts like Delhi and Bombay are very quick, even if you need to approach an Indian court in aid for arbitration. The arbitration bar is really developing in India. Now, courts are exceedingly appointing professionals who are arbitrators rather than just retired judges. And it is making a big difference in the way arbitration is viewed as a mainstream dispute resolution mechanism. It is quick, it is effective. So, my suggestion is if you are a foreign party looking to enforce against an Indian party, you have two good options for interim release. Seat your arbitration in a good commercial jurisdiction, pick Delhi, Bombay, whatever works for you. Or pick a good institution, but seat your arbitration in India. So you have the option of both approaching an Indian court in a 9, which is a section applicable to interim reliefs, or in an emergency award, which is enforceable in India. And they're both very effective.
There's a question which will put you on the spot. Between ad hoc and institutional arbitration, and institutions, whether in India or outside, what do you pick and how?
Okay, so there is no one answer, and I'll tell you why. So there's two things to consider. Your deal value, right? So institutional arbitrations could be expensive. So if you're looking at a mid to small size deal, and if you're looking at say counterparties in Asia, I would suggest that you could do a very effective ad hoc arbitration with the kind of bar that we have right now. So if you choose the right arbitrator, you could have a very effective arbitration both time-wise and cost-wise through ad hoc as well. But if you're looking at a more sort of large-size deal, my recommendation would be institutional, simply because it streamlines the process a little bit, especially if it's a multi-party contract. It can make a big difference. notwithstanding the cost. As far as Indian institution versus foreign institutions are concerned, Indian institutions are getting there. They're getting better, each day. But unfortunately, we're not there yet. So my recommendation still would be maybe a SIAC for an Asia-centric dispute, or maybe an ICC for a larger dispute, but not yet an Indian institution. But we are getting there. That's the good news.
Understood. Um, I'm conscious of time, so I'm going to now pick out of the various slot that we have. So let's move to expert determination, particularly in the context of post-closing adjustments and what have you. It's very common to have accountants or those sorts of people. How do we view expert determination, and where does it stand in the overall scene of affairs in terms of a dispute? And what are the pitfalls to avoid when going through an expert determination process?
It's actually a very good question. We've actually just dealt with this in a very recent live dispute that we're dealing with currently. Expert determination can be a very, very useful tool, especially when you're talking about a technical matter or a technical dispute. I mean, as lawyers, as arbitrators, we're not best equipped on the technicalities. It may just be that an expert is better placed to resolve this. So typically, we see this in multi-tiered arbitration clauses, where you will have an amicable resolution followed by an expert determination, ultimately followed by an adversarial process, which is typically arbitration in most contracts. So in this situation, I think it's a very effective tool if you're looking at a technical dispute, but you need to make sure that the contours of the determination are clearly defined. You need to ensure that you have a timeline for the expert. You need to ensure that you have parameters for the expert to determine. You need to ensure that you have a mechanic in place for who's going to appoint that expert. Is it going to be mutual? Is it going to be an institution? How is it going to happen? So you need to have all of these metrics clearly defined. And if you do that and you have an expert determination, you also need to ensure that you stipulate whether that determination is binding or disputable in an arbitration. So that is also an issue that could play a role. So as clearly identifying all of these parameters can make life much simpler.
Understood. There's a very interesting question going away from our traditional litigation points. And they're saying, do you see conciliation and now mediation with the new mediation law? Are these being used to resolve disputes before they actually hit arbitration or courts?
That's a very good question. So we're seeing a lot of traction around mediation. In fact, I was having a discussion with a colleague just yesterday around this. Yes, there is a lot of traction around it. The formal systems are not yet in place, but there is a lot of interest. There's a lot of training. There, again, similar to an arbitration bar, there is a bar that is coming up that is interested in institutionalizing this mechanism. So while I haven't seen it being used effectively yet, I think it's very nascent. The act is very recent. I do see this forming more and more an effective dispute resolution mechanism, especially for your smaller value disputes or your mid-sized disputes where parties don't necessarily want to incur the cost of an arbitration, and where you really, if you distill it down to key issues, you're really looking at one or two issues which may have a better mediated settlement result for both parties than a contested arbitration result for either.
Understood. A connected point. Sometimes we say mediation before arbitration in the clause. We specify senior executive officers have to meet, they have to sort out. I'm going to rephrase the question, but it essentially is talking to the fact that if you have those processes before actually going to arbitration or court, to what extent must you follow those processes to the T, or can you take some liberties and maybe skip a step or two?
So, how you draft your clause may also make a difference, but generally, the position that is taken is that if you can show through correspondence that an extensive level of discussions has already taken place between the parties, then courts don't tend to enforce these clauses very strictly because they take a view that if you have been writing to each other for the last year or so, or 2 years, and you have exhausted everything that you need to say on the issues, just because the clause prescribes a mediation, asking you to go through that rigmarole may not serve a useful purpose. Now, what will be interesting to see is if we have a more institutionalized mechanism that does actually make a difference in terms of a trained mediator intervening, whether the courts will likely take a slightly different view. Because right now, what you're talking about is really informal sort of discussions between parties who may not necessarily be in the same position as maybe a qualified mediator to sort of distill issues and find that middle ground. So I would be quite curious to see how courts react once we have a slightly more mediated position. But today, unfortunately, the position that we have is that they're not mandatory.
Understood. Understood. Um, okay. Again, there's a question on IP licensing, but I'll just try and rephrase that. So let's say there's a transaction. It has two or three different kinds of agreements: a share purchase agreement, a trademark license, and so on. They're saying, is there any is there any benefit or merit in having the same dispute resolution across all agreements, or can you have, for example, in IP licensing, uh, directly courts and not arbitration? Is there any thought process there? And also a connected question I'll add: how do you consolidate arbitration across multiple agreements if there are different
Sure.
agreements and the disputes across two?
So my recommendation typically is that it's best to have a consistent clause across all of your contracts when they're interconnected agreements. This is because you don't want to be running between a court that may or may not give you the injunction and a tribunal that may or may not give you the injunction, have two conflicting positions at both ends to deal with. It's really an interconnected transaction. You want to have one effective mechanism that applies across the contract. So definitely have a common dispute resolution mechanism across your contracts. In terms of consolidation, most of the leading institutional rules actually allow for consolidation in typically three situations. Either all of the parties to the contracts are the same, the dispute resolution process across the contracts are same, or where there is a disjunct between parties, say party A and party B are parties to one agreement, but party B and party C are to the other, but they're really interconnected if one is a subcontract of the other. As long as all parties consent before the constitution of the tribunal, the institution will allow for consolidation. So these are typically the three situations in which they will allow for consolidation of disputes, and it's aimed to ensure that there is a consistency where you can show that the contract is really one integrated transaction in whole.
Understood. I have an extremely interesting question I'd like to end the Q&A session on. I'll give some context. So as we know, Mr. Elon Musk made an offer to buy Twitter, a very seller-friendly offer that he made. And eventually, for whatever reason, A or B or C, he decided to say that, no, I'd like to walk away from the transaction. The matter went to the Delaware court. So the question is, if the Twitter transaction was to be brought to an Indian court, what is what is your view on the chances of the Indian court directing Elon Musk to actually close the transaction?
I would say fairly good, given the view that the Indian courts have taken, which is pro enforcement. If he made an offer in good faith and hasn't had any serious basis to really walk away from it, an Indian court, I think, would definitely hold him to it, and definitely the Delhi High Court would do that if nobody else would.
With that, ladies and gentlemen, I'm sorry there are far too many questions and far too little time for us. But nonetheless, with that, what we'll do is maybe move on to our next segment, which is a poll. I'll request my colleagues to move to the poll. This is part of our feedback, and if you could please share your feedback on the slide in front of you. Right. With that, just I'd like to quickly summarize some key takeaways for me from today's webinar. And we see this as a part of our daily lives, but disputes can arise at any and every part of the contract. In some cases, they're unexpected, but in some cases, dare I say, they are quite predictable. You just need to have the eye and the vision for it. And depending on each party's commercial priorities and risk appetite, it's actually very important to build in sufficient protections for the party in any such transactional document. And believe you me, ladies and gentlemen, this only happens when you have advisors who have lived through the life cycle of such transactions. We discussed the term sheet, diligence, disclosure, actual agreements, post closing adjustments. Your advisors need to be able to help preempt at the outset what those complexities are. With that, thanks once again to everybody who participated in the poll. And finally, many, many thanks, Neha, for sharing your expertise and your experience with us today. simply outstanding presentation. Thank you so very much.
Pleasure. Thank you.
And many thanks to our audience for your attention, your truckload of questions. We will circle back after the webinar for all of the questions we've missed. We do hope you enjoyed this webinar and found this to be a relevant investment of your time. For us, it was an absolute pleasure. And just to summarize, we will be sending you a copy of today's presentation, the materials and the summary notes, along with a link to the webinar recording. We will also circulate a separate request for feedback. Please do take the time to send us this feedback. The form has been engineered to be short and crisp. It takes less than a minute to complete. And if you are interested in in-house training or any other matters arising from this webinar, please do not hesitate to contact Sneha or me. Our contact information is on the slide in front of you. Thank you very much, ladies and gentlemen. Have a wonderful day ahead.